I would like to start the online public lecture and Pak Priyo, wait, hold a second. Priyo, ini perpindahan speakernya belum? Perpindahan speaker. Maksudnya kalau ngomong kan nggak kena view. Udah. Oke. Ya, aku mau mulai. Oke. Ini masih panusi soalnya di layar aku. Oke. Okay. Thank you so much. Well, ladies and gentlemen, I would like to start our online public lecture and campus tour today. Okay. Let's Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Good afternoon, ladies and gentlemen. Good morning for Miss Julia and also Mr. Yasser Bakil because the time differences. And can we start? Hello. Okay. Hold a second, I'm trying to confirm the operator. Pak Priyo, siap enggak? Okay. Well, thank you so much for being here today. We have to thank God the Almighty that we are here in a healthy condition so we can hold this online public lecture and campus tour for Saturday, 18 September 2021. Ladies and gentlemen, it is an honor for me as the moderator today that I would like to start the meeting by saying Basmalah. Bismillahirrahmanirrahim. Ladies and gentlemen, let's listen to the national anthem Indonesia Raya. Bapak Ibu dimohon berdiri. Please raise for the national anthem Indonesia Raya.
Звучит национальный гимн Индонезии, всех просит встать.
Indonesia bersatu, hiduplah tanahku, hiduplah negeriku, bangsaku, rakyatku semuanya. Bangunlah jiwanya, bangunlah badannya untuk Indonesia Raya. Indonesia Raya, merdeka, merdeka, tanahku, negeriku yang kucinta. Indonesia Raya, merdeka, merdeka, Indonesia Raya.
Thank you for listening to the national anthem of the Republic of Indonesia. Ladies and gentlemen, please listen to the national anthem of Morocco. Masih berdiri Bapak Ibu. Ladies and gentlemen, let's listen to the national anthem of Russia. Thank you so much, ladies and gentlemen. Please be seated. Yeah. Well, before we go to the main agenda, I would like to invite, it is an honor for me to invite the head of Master of Law, Universitas Pancasakti Tegal, Dr. Sanusi SHMH, to deliver the opening speech. Dr. Sanusi, please do.
Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Good afternoon.
Waalaikumsalam.
The Honorable Director of Postgraduate Program, Prof. Dr. Siti Hatina. The Honorable Prof. Dr. Hollis, SHM from Universitas Diponegoro, the Honorable Mr. Joseph Bakil, Hassan Fas University, Morocco, the Honorable Mrs. Parkova Yulia, Moscow City University, Russia, distinguished participants, ladies and gentlemen, I am pleased to welcome you to online public lecture on intellectual property right and campus tour today. This is KKL in pandemic era. Its aim at providing more knowledge and perspective from different countries. A warm welcome to you all. Equally important is how collaboration is this great effort. Dear colleagues, this is an important agenda, but also a fast one, and the time available to us is limited. But we have also heard from you through your responses to our online feedback. Your inputs are much appreciated. Ladies and gentlemen, I believe that by participating in this webinar, we are in the right place and the right time. Together, let us accelerate the exchange of ideas and calling up of good practices. I am confident that you will find an idea. I wish you all a very successful agenda. Thank you. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam. Thank you so much for a very warm welcoming speech, Dr. Samsi, the head of Master of Law, Universitas Pancasila Tegal. It is an honor for me to invite the Director of Postgraduate Program, Ibu Professor Dr. Siti Hartina SH, I'm sorry, MPD. I'm so sorry. Okay, please do.
Bu Yoga, terima kasih. Thank you, Bu Yoga. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon. The Honorable Master of Law, Universitas Pancasila Tegal, Dr. Sanusi SH. The Honorable Professor Dr. Hollis Roisoh SHM from Universitas Diponegoro, Semarang. The Honorable Mr. Joseph Bakil from Hassan Fas University, Morocco. The Honorable Miss Starkova Yulia from Moscow City University, Russia. Distinguished participants, ladies and gentlemen, greeting to one and all. It gives me immense warmth and great pleasures to grace all of your presence. It gave me tremendous contentment to be presenting the short remarks amongst the most esteemed speakers and participants who are student of Master of Laws, Universitas Pancasila Tegal. Before we begin public lecture and campus tour, I would like to express my heartfelt gratitude to all of you who sincerely committed to this event to make it a success. This event would have been impossible without the support of each and everyone present here. These events are organized and conducted for participants to gain insight and information that would remain effective in their lives, exercises, and works. Its topic for discussion and debates for today's seminar is choose, keeping in mind the interest of youths. The schedule of the seminar includes discussion and debate by the esteemed delegates. I am sure the seminar will be profitable and fruitful for everyone present here. Thank you on one and all. Thank you very much. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
Here is very crowded, so the sound is everywhere. Thank you, everyone. Thank you. Kompak banget ya Bapak-bapak ya. Okay, thank you so much for a very enthusiastic reply. Terima kasih untuk antusiasmenya Bapak Ibu.
Saya ke situ rame.
Rame Bunda di sini banyak ini para politisi.
Soalnya saya.
Okay, thank you so much for a very warm welcome, Professor Dr. Siti Hatnina, MPD. Before we start, I would like to check Professor Hollis. Halo Professor, is the sound, apakah suara Ibu bisa didengar? Maksudnya kita cek suara Ibu.
Oh ini.
It's okay.
Okay.
It's okay.
Okay, thank you. Because before we had a trouble.
Your voice is having your voice.
Thank you, Professor. Well, ladies and gentlemen, I would like, before we go to the main agenda, I would like to introduce our speakers to our main table. Pak Brio, please. The first speaker or the keynote speaker will be Professor Dr. Hollis Roisa SHM from Universitas Diponegoro. She was the chairman of the Regional Craft Council Rembang. She was also accreditation board assessor at Universitas Diponegoro. Head on duty for Master of Law 2018 to 2019, the Assistant Director of Planning and Development Agency 2019 to present. Next speaker is the Honorable Mr. Yosef Bakil, Researcher in Public Law and Political Science in Faculty of Law and Political Science, Hasan First University. Pak Brio, tak kelihatan. Hold a second. Okay, and the General Secretary of Center of Research and Studies on Migrations and Human Rights, the local coordinator of Students for Liberty. This is an international organization created in USA and have departments in all world countries. International speaker in a lot of conferences. Bapak Ibu, di-mute dulu nggih kalau yang ini biar suaranya nggak masuk. Terima kasih. And the next honorable speaker is Mrs. Sarkova Julia. Yeah, Sarkova Julia, Senior Lecturer of the Department of Civil Law and Procedure of the Samara campus of Moscow City University, Samara, Russia. In 2018, she graduated from the postgraduate study in the directions of training, constitutional law, and process. In 2015, she graduated from the Saratov State Law Academy with a degree in jurisprudence, and research interest is human rights. Ladies and gentlemen, I have introduced all the speakers, so it is an honor. Before we start for the first speaker, it is an honor for me to introduce you to OTA video provide. Pak Priyo. Nanti dibahas silakan. Bapak Ibu siap-siap Google Translate kalau nanya.
International Summer Camp 2019.
Event organized by Universitas Tegal.
The Indonesia and its whatever is the culture and people is very cool. Good luck tonight. Thank everybody. I speak Indo.
He's from University Tegal. He's the first mobility student.
Yo guys, my name is Walidin. I am the student of the University Tegal, Indonesia. I am also one of the students who got the opportunity to join the international program. I mean international scholarship. It was transfer credit program. It's quite similar with student things, but I didn't go to Thailand. I just stayed at home for online class.
Halo, saya Vindi Franska Putiati, mahasiswa Fakultas Ekonomi dan Bisnis Universitas Tegal. Saya adalah salah satu mahasiswa yang mengikuti program beasiswa transfer kredit ke Tegal Global University, khususnya ke Tegal Global.
Perkenalkan, saya Ahmad Zainuddin, mahasiswa program studi Pendidikan IPA, Fakultas Keguruan dan Ilmu Pendidikan, Universitas Pancasakti Tegal. Pada hari ini, saya sedang mengikuti perkuliahan di Trademark Agricultural University of Philippines.
My name is Atmo Kusumo. I'm student of Pancasakti Tegal University, Indonesia, and I do teaching internship in Krabi, Thailand for 5 months. And today, I would like to show you around my school. So, let's go. Ini.
Bro,
Oh, mì khao.
Mì khao, mì Nam.
Khoai thiểu, mì Nam.
Mì súp.
So now we arrive in Intramuros. Intra, it means intern. Intern, right? Oh, no. Inside. So Muros, it means.
Ditempatkan di PT Semen Indonesia Pesawat Tegal di bagian Unit of Product Management.
عليكم أنا أحمد من مصر. دلوقتي أنا بدرس اقتصاد وإدارة أعمال في جامعة تيجال OPS في إندونيسيا. تقريبا إندونيسيا من أكتر الدول اللي أنا بحبها في حياتي، أو ما كانش هي تكون أول دولة بحبها في حياتي أصلا، لأن الناس بتاعتها بصراحة لذيذة جدا. يعني الكالتشر بتاعتهم، الثقافة بتاعتهم، تحس إن مفيش أي اختلاف ولا في أي حاجة، تحس إن أنت بتتعامل مع
My name is Surapatuddin, or you can call me Masnura. I'm from Thailand. I study program English department of Universitas Pancasakti Tegal.
Thank you so much. Well, thank you so much to the operator. Ladies and gentlemen, let's go to the main agenda. It is an honor for me to invite the Untitled Speaker, Mr. Yosef Akil from Universitas University. Mr. Yosef Akil, please do. Bapak Ibu, nanti materinya saya upload the chat box.
Hello everyone, thank you Madam Yoga. Bismillahirrahmanirrahim. Salatu wassalamu ala ashrafil mursalin Sayyidina Muhammadin wa ala alihi wa sahbihi ajma'in. Rabbi shrah li sadri wa yassir li amri wa hlul 'uqdatan min lisani yafqahu qawli. I would like to thank Madam Yoga for inviting me to this event, of course, as well as all the speakers and participants of this event. So my contribution is about a very important topic. It's the intellectual property right in the Moroccan context. So I will start with the definition of intellectual property right. What are intellectual property rights? Intellectual property rights are the rights given to persons over the creation of their minds. They usually give the creator an exclusive right over the use of his/her creation for a certain period of time. Intellectual property rights are customarily divided into 5 main areas. Firstly, copyright and rights related to copyrights. The rights of authors of literacy and artistic work, such as books and other writing, musical composition, painting, sculpture, computer programs, and films are protected by copyrights for a minimum period of 15 years after the date of the author. Also protected throughout copyright are related, sometimes referred to as neighboring rights, that are the rights of performers, e.g. actors, singers, and musicians, producer of phonogram, sound recording, and broadcasting organizations. The main social purpose of protection of copyrights and related rights is to encourage and revert creative works. So now we will move to the second one, industrial property. Industrial property can usefully be divided into 2 main areas. One area can be characterized as the protection of distinctive signs, in particular trademarks, which distinguish the goods or service or one undertaking from those of other undertakings, and geographical indicators, which identify a good as originating in a place where its given characteristic of the good is essentially attributable to its geographical origins. The protection of such distinctive sign aims to stimulate and ensure competition and to protect consumers by enabling them to make informed choices between various goods and services. The protection may last indefinitely provided the sign in question continue to be distinctive. Other types of industrial property are protected primarily to stimulate innovation, design, and the creation of technology. In this category, fall innovation protected by patents, industrial design, and trade secrets. The social purpose is to provide protections of the result of investment in the development of a new technology. This given the incentive, the mean of finance research and development activities. A functioning intellectual property regime should also facilitate transfer of technology in the form of foreign direct investment, joint ventures, and licensing. The protection is usually given for a finite term, typically 20 years in the case of patents. While the basic social objectives of intellectual property protection are as outlined above, it should also be noted that the exclusive rights given are generally subject to a number of limitations and exceptions aimed at the first tuning the balance that has to be found between the legitimate interest of rights holders and of users. Now we will move to the patent. A patent is used to prevent an invention from being created, sold, or used by another party without permission. Patents are the most common type of intellectual property rights that come to people's mind when they think of intellectual property rights protection. A patent holder has every right to commercialize his/her patent, including buying and selling the patent or granting a license to the invention to any third party under mutually agreed terms. The trademark. Trademarks are another familiar type of intellectual property rights protection. A trademark is a distinctive sign which allows consumers to usually identify the particular goods or service that a company provides. Some examples include McDonald's, Golden R, the Facebook logo, and so on. Trademarks can come in the form of text, a phrase, symbol, sound, smell, and or color, shape, and like patents. A trademark can protect a set or class of products or service instead of just one product or process. Trade secrets. Trade secrets are the secret of business. They are proprietary systems, formulas, strategies, or other information that is confidential and is not meant for unauthorized commercial use by others. This is a critical form of protection that can help business to gain a competitive advantage. Now we will move to the importance of intellectual property rights. Why intellectual property rights is very important. The purpose of intellectual property rights is to encourage new creations, including technology, artwork, and inventions that might increase economic growth. Intellectual property rights increase the initiative for individuals to continue to product things that further create jobs, opportunities, and new technologies, while enabling our world to improve and evolve even faster. Now we will move to the Moroccan context, the intellectual property rights in Morocco. Morocco has relatively comprehensive regulatory and legislative system for the protection of intellectual property. Intellectual property rights, however, must be registered in both Casablanca and Tangier in order to be protected in Morocco. Morocco is a member of the World Intellectual Property Organization, the WIPO, and party to a member of other international agreements and conventions dedicated to the protection of intellectual property, including the Berne Copyrights, Paris Industrial Property and Universal Copyright Conventions, the Brussels Satellite Conventions, and the Madrid, Nice, and the Hague Agreement for the protection of intellectual property. Morocco was considering enactment of a new law of industrial property protection in a bid to stop illicit use of international brands or marks by local companies. Although Morocco is under various obligations tied to its membership to the GATT since 1994. The new commerce law of May 1396 did not include any provision strengthening intellectual property rights. The patents. Any individual or legal entity may file an application for a patent with the Moroccan Patent Office in Casablanca. The Patent Office examines applications with regard to form only and not with regard to novelty or merit. The particularity of the application are published. In the Office Gazette, no opposition procedures is provided. Patents issued are valid for 20 years. Universal novelty of the invention is required by law to grant a patent, and working of patents issued required by law to maintain the patent. Patent right may be freely transferred to third party. However, the transfer must be registered with the Patent Office in order to be effective against third parties. Trademarks. The international classification of goods is followed. In Morocco, trademarks applications are examined by the Trademark Office only with regard to form. Registered trademarks in the preceding years are published in a special trademark supplement of the official Gazette. No opposition procedure is provided. Registered trademarks invalid for 20 years from the date of registration, renewable for additional 20 years periods. Transfer of trademarks rights must be registered with the Trademark Office within 3 months in order to be valid against third parties. Infringement of registered trademarks may be punishable under either the penal or civil law in Morocco. Copyrights. Moroccan law provides copyright protection for the literary or artistic expression of an idea, and there are the registration requirement to invoke such protection. A copyright confers upon the author two principal rights: a property right and ethical rights. The property right gives the author the exclusive right to exploit the copyrighted work for pecuniary gain. This right extends throughout the author's lifetime and therefore is transferred to be benefits to the author heirs for a period of 50 years. The ethical rights protect an author non-pecuniary interests in the literary artistic work, which includes the protection of authorship and integrity. This right is perpetual and inalienable and remains with the author until date, and thereafter with the author. Here, authors may sell all or parts of their property rights or the right to perform or reproduce the work without forfeiting their ethical rights. So this is all about my presentation, and if you have any question or inquiries, I will send you all my paper to Madam Yoga, and she can share it, I think, with you all. Thank you, everyone.
Yeah, thank you so much for very nice presentations, Mr. Yosef Akil. Pak Priyo, aku kedengeran nggak suaranya?
Kedengeran.
Ya? Thank you.
Thank you very much.
Oke, Bapak, saya harus terjemahkan sedikit, ya. Oke, jadi ini Morocco in general. Jadi di sana sama ya Bapak, untuk hak kekayaan intelektual ini ada trademark, patents, copyright, and also ini Mr. Yosef Akil hanya menerangkan industrial property, ada kayak industrial. Kemudian secara umum sama di register dulu. But I don't know why is copyright in Morocco no need to be registered for the protect. I don't understand this in your PDF. Ini tidak perlu diregister Bapak Ibu untuk copyright ya, especially. Am I right, Mr. Yosef Akil? Betul nggak? Betul nggak? Dia nggak tahu ya. Am I right, Mr. Yosef Akil? Hello, are you there?
Can you repeat, Madam Yoga? I can't hear you.
Okay. So in Morocco, di Morocco Bapak Ibu ini copyright menurut according to Mr. Yosef Akil ini tidak no need to be registered. There are no registrations requirements for copyright. Am I right?
Yes, the Moroccan law, you need to register the copyright in the port of Casablanca and Tangier. This is two cities in Morocco. We have two centers to register the copyright here in Morocco.
Oh, diregistrasi ternyata di Tangier atau di Casablanca. Jadi di sini juga ada validasinya 20 tahun Bapak Ibu untuk trademarks kayak di Indonesia. Mungkin nanti kalau di Indonesia dijelaskan oleh Prof. Hollis karena saya bukan dari hukum ya Bapak Ibu. Kemudian untuk paten juga ini sama, valid untuk 20 tahun di Maroko. Kemudian ini untuk ya, sudah dijelaskan di sini secara umum bahwa untuk intellectual property right diregistrasi di Casablanca dan Tangier. Only two cities in Morocco for registering the copyright, the intellectual property right. Only two. Okay, is it online?
Only two in Casablanca and Tangier.
Okay, is it online registrations or?
No, I don't think so. It's, I think, an administrative procedure. You should go to the center.
Oh, tidak bisa online, Bapak Ibu. Kalau di Indonesia mungkin sudah online ya, Pak. Mungkin ada yang bisa jawab pertanyaan saya. Ya, kalau in Indonesia, we can register our intellectual property right online. But in Morocco not. Go to the center directly. Kalau di Morocco Bapak Ibu tidak bisa, harus ke centernya directly. Secara langsung, tidak bisa online. Oke, Bapak Ibu, kira-kira seperti itu secara umum ya gambarannya ya. Terima kasih. Thank you so much Mr. Yosef Bakil. Bapak Ibu kalau ada pertanyaan bisa ditulis di chat box, tapi nanti saya langsung ya, mau langsung. Ada yang nulis. Oke, langsung. Mr. Yosef Bakil, one question only from Rizky, Pak Rizky Fajar. You see the chat box, only one before you leave. Yeah.
What is the main problem?
What is the main dari Ibu Soliha? What is the main problem in enforcing the violation international property right in Morocco? Ya, ini dulu deh Pak Rizky ya. Okay, Mr. Yosef Bakil, you may answer. What is the main problem?
Can you precise the question, please? I don't understand what you want mean.
Okay, so there are violations in intellectual property right in Morocco, I believe. And what is the main problem in solution in overcoming these violations in Morocco, especially?
I don't think so. We have violation of intellectual property rights in Morocco. We have the liberty to express our ideas here. So you can say what you want. If I understand the question.
No, it's different. So, for example, I have the copyright in music, okay? And then somebody is copying my music without permissions. Okay, so what is the main problem in overcoming these violations or infringement, if I'm not mistaken in English, in Morocco? So what is the main problem? The weaknesses for your, maybe in the government?
Punishment in
law punishment, yes. But
yes, the penal law and the civil law here in Morocco, we have a lot of punishment for that.
Ya, Bapak Ibu ada law punishment, ada hukumannya, of course.
Between 1 year to 5 years.
1 sampai 5 tahun. But in punishing these persons, what is the main problem found in the implementations of punishment? Any problems or not? Do you think so?
Oh, there are no. There are no problems.
Okay. Jadi menurut Mr. Yosef Bakil itu belum ada masalah ya untuk mengatasi, kan Bapak tadi nanya apa sih problem utama dalam pelanggaran copyright gitu ya, pelanggaran intellectual property right gitu ya. Nah, ini Mr. Yosef Bakil hanya menerangkan bahwa itu di punish how many years? 1 to 5 years, right? 1 to 5 years. Okay, 1 sampai 5 tahun di Maroko. So any cases, big cases about this in Morocco? Ada nggak kasus-kasus besar yang nggak ngerti juga bahasa Indonesia ya? Any big cases?
Yes, of course. There are
what is the big cases? What is the big case of the violation?
There are not the big cases. They are just the cases because I think in every country there are similar punishment like that. I think. What's the case in Indonesia? What is the situation in Indonesia? You have a lot of cases, or it's normal?
Okay, ya di sana juga banyak pelanggaran Bapak Ibu. Tapi untuk punishment-nya sementara ini belum ada masalah yang berarti gitu nih Bapak Ibu nggih. Terima kasih. Thank you so much Mr. Yosef Bakil for the answers.
Thank you.
So ladies and gentlemen, it is an honor for me to invite the second speaker, the Honorable Mrs. Starskova Julia. Please do.
Для нас большая честь пригласить сейчас в качестве нашего второго спикера уважаемую госпожу Юлию Старкову. Она готова.
Еще раз поприветствую всех участников. Здравствуйте.
First and foremost, allow me to greet all the distinguished participants of this conference. Hello, good morning.
Good morning.
Сейчас попробую загрузить презентацию.
I'm just opening my presentation.
Enggak bisa. Terus apa entah transfer data, transfer paket data. Ya, belum.
Тему мы еще раз представлюсь. Юлия Старкова, старший преподаватель кафедры гражданского права и процесса Самарского городского педагогического университета, Самарского филиала.
Allow me to introduce myself once again. My name is Julia Starkova. I'm the senior lecturer at the Department of Civil Law and Procedure at the Samara branch of Moscow City University.
Тема выступления: интеллектуальные права в России, правовое регулирование.
And I'm going to speak about the legal regulations of intellectual property rights in Russia.
Творческая интеллектуальная деятельность является особенностью человека. Человек не может не творить. Творчество, созидание, генерирование новых идей, решений, образов, представлений создают человеческое общество, позволяет ему двигаться вперед. Творчество представляет собой познание нового, ранее неизвестного.
The creative and intellectual activity is an inherent capability of a human being. A human and its creativity is something very important. The creativity, the creation, generation of new solutions, ideas, and images is what creates the human society and enables us to move forward. Creation is the process of understanding something new, something which is not known before.
Сами результаты творческой деятельности, будучи порождением ума, являются нематериальными, и это позволяет им распространяться по миру с большой скоростью. Идеи и образы, в отличие от материальных объектов, вещей, могут использоваться одновременно огромным количеством людей.
The results of creativity, because they are the products of the mind, are immaterial, and that which enables them to spread around the world with a large speed. The ideas and images, unlike material objects or things, can be used simultaneously by a great number of people.
Нематериальные блага пользуются правовой охраной давно, но лишь относительно недавно продукты творческого труда стали рассматриваться как объекты присвоения, то есть приобрели природу товара и стали оборотоспособными.
The immaterial assets have been protected for quite a long time, but quite recently they began to be regarded as marketable objects, and they became goods, and this is how they became negotiable.
В Российской Федерации вопросы охраны и защиты результатов творческой интеллектуальной деятельности приобрели актуальность в период развития рыночной экономики. Повышение уровня защиты прав на объекты охраны интеллектуальной собственности является необходимым условием динамичного развития экономики нашей страны.
In the Russian Federation, the questions of protection and of the results of creative and intellectual activity became especially important in the period of development of our market economy. The increase of the level of protection of rights for the intellectual property of objects is an indispensable condition for the dynamic development of economy of Russia.
Интеллектуальные права регулируются в основном на национальном уровне. На международном уровне такие права урегулированы в относительно малой степени. Главным образом определяется порядок национального законодательства в отношении пользователей прав из других стран, а также условия международного оборота прав на объекты интеллектуальной собственности.
The intellectual property rights are usually regulated on a national level, whereas on the international level, such rights are regulated to a lesser degree. Mainly, we identify the order of application of the national law with respect to intellectual property rights users from other countries and the conditions of the international interaction of rights for the objects of intellectual property.
Вместе с тем, составной частью российского законодательства в области защиты интеллектуальных прав являются многосторонние и двусторонние международные договоры. Ряд из них представлен на слайде.
At the same time, one part of the Russian legislation in the field of intellectual property rights is the multilateral and bilateral international treaties of the Russian Federation. And some of them are given here on this slide.
Следует отметить, что работа по их подготовке и принятию началась достаточно давно. Еще в конце XIX века было подписано самое первое международное соглашение в сфере интеллектуальных прав. Это Парижская конвенция по охране промышленной собственности 1883 года.
However, we should mention that the work on the preparation and adoption of such international treaties started quite a long time ago. It was back in the late 19th century that we signed the first international agreement in the sphere of intellectual property rights. That was the Paris Convention on the Protection of Industrial Property, dated 1883.
Целью принятия этой конвенции было преодоление территориального действия охраны исключительных прав и международная защита прав интеллектуальной собственности. Международные стандарты, установленные Парижской конвенцией по охране промышленной собственности, сегодня поддерживаются большинством стран мира. Так, в Парижском союзе участвует более 160 государств.
The objective of the Paris Convention was to overcome the only territorial application of intellectual property rights protection and international protection of such rights. The international standards, which were set by the Paris Convention of 1883, are supported by the majority countries of the world. Today, the Paris Convention Union engages more than 160 states internationally.
Важнейшим из международных соглашений, охватывающих широкий спектр отношений в сфере интеллектуальной собственности, относится также соглашение по торговым аспектам прав интеллектуальной собственности 1994 года. Российская Федерация присоединилась к соглашению в 2012 году.
Some of the most important international agreements, which encompass a broad range of relations in the sphere of intellectual property, is the Agreement on Trade Aspects of Intellectual Property Rights of
Соглашение содержится...
and the Russian Federation joined this agreement in 2012.
В соглашении содержатся обязательства стран-участников по соблюдению международных стандартов охраны прав интеллектуальной собственности от различных нарушений, а также правила по разрешению споров. Предметом соглашения являются также авторские и смежные права, товарные знаки, указание мест происхождения товаров, промышленные образцы и модели, изобретение, топологии интегральных микросхем и защита производственных секретов.
This agreement contains the obligation or the obligations of participant countries on compliance with international standards of protection the intellectual property rights from various infringements and the rules for the resolution of conflicts. The object of the agreement is the author and ancillary rights, the trademarks, the indications of locations of the production of goods, industrial models and prototypes, inventions, topologies of integral chips, and the protection of trade secrets.
Соглашением в сфере авторского права является Бернская конвенция по охране литературных и художественных произведений 1886 года. Это первый унифицированный международный нормативный и правовой акт, закрепивший основные стандарты в области авторского права.
Another agreement in the sphere of copyright is the Berne Convention on the Protection of Literary and Artistic Work and Artwork of 1886. This was the first unified international normative and legal act which regulated the major standards in the sphere of copyright.
В конвенции государства-участники зафиксировали свое намерение защитить наиболее эффективным унифицированным образом права авторов на литературные и художественные произведения.
The participating countries stated their intention to protect in the most effective and a unified way the rights of the authors to literary and artwork.
В части национального законодательства в соответствии с Конституцией Российской Федерации интеллектуальная собственность охраняется законом, а законодательство об интеллектуальной собственности относится к ведению Российской Федерации. Это означает, что законы в этой области могут приниматься только на федеральном уровне.
As far as our national legislation is concerned, in compliance with the Constitution of the Russian Federation, the intellectual property is protected by law, and the legislation on intellectual property is governed by the Russian Federation, which means that the laws in this area may only be adopted on a federal level.
Отношения, связанные с охраной и использованием объектов интеллектуальной собственности, входят в предмет регулирования гражданского права. Главным источником права интеллектуальной собственности является Гражданский кодекс Российской Федерации.
The relations related to the protection and use of the objects of intellectual property are under the regulation of civil law, and the major source of the rights of intellectual property is the Civil Code of the Russian Federation.
В систему норм, регулирующих отношения в сфере интеллектуальной собственности, входят и другие законы, они обозначены на слайде.
However, the system of the norms regulating the relations in the sphere of intellectual property involves some other laws and acts, and they are shown here on this slide.
Российское законодательство устанавливает перечень объектов интеллектуальной собственности, которые можно условно разделить на две группы. Это результаты творческой деятельности, к ним относятся произведения искусства, литературы, науки, программы для электронно-вычислительных машин, изобретения, промышленные образцы, полезные модели. И вторая группа – это средства индивидуализации, товарные знаки и знаки обслуживания, фирменные наименования, наименования мест происхождения товаров, а также коммерческие обозначения.
And the Russian legislation states the list of objects of intellectual rights, which can be roughly divided into two groups. First is the results of creative activity, works of science, literature and art, computer programs, inventions, industrial designs, and so on. And on the other hand, the means of individualization, which includes trademarks and service marks, brand names, appellations of origin, and so on.
Наряду с этими объектами можно выделить и так называемые нетрадиционные объекты, к которым относятся селекционные достижения, топологии интегральных микросхем, а также секреты производства, ноу-хау.
But apart from these two traditional areas, there also can be, we can also single out the so-called non-conventional objects, which include achievements of selection, topology of integrated circuits, and production secrets, or know-how.
Субъектами интеллектуальных прав являются авторы, работодатели и инвесторы. Авторы – это физические лица, чьим трудом создаются интеллектуальные продукты. Их деятельность носит творческий и сугубо индивидуальный характер. Работодатели и инвесторы – это лица, занимающиеся коммерческой эксплуатацией исключительных прав.
So who are the subjects of intellectual rights? They include authors, employers, and investors. The authors are individuals, and they use their labor to create intellectual products. On the other hand, the employees and investors are the people who are involved in the commercial use of these exclusive rights.
На результаты интеллектуальной деятельности и приравненные к ним средства индивидуализации признаются интеллектуальные права, которые включают исключительное право, являющиеся, естественно, преимущественным правом, личные неимущественные права, а также иные права, такие как право следования, право доступа и другие.
The results of intellectual property are covered by the intellectual rights, which include the exclusive right, the personal non-proprietary rights, and other rights such as the right to follow, the right to access, etc.
Первоначально эти права возникают у автора результата творческой деятельности. Исключительное право позволяет автору распоряжаться объектом и правами на данный объект.
Initially, such rights arise with the author of the result of creative activity, and the exclusive right enables the author to dispose of the object and of the rights for this object.
В то же время личное неимущественное право определяет автора результата интеллектуальной деятельности, возможность автора использовать объект или разрешать его использование под своим подлинным именем или анонимно, а также неприкосновенность созданного автором произведения.
The personal non-property rights enable the author to use this object of intellectual property, to allow its use under their real name or anonymously, and to ensure the intangibility of this work of the author's labor.
Исключительное право является ядром интеллектуальных прав, тем имущественным правом, которое и обеспечивает экономический оборот. Интересной особенностью исключительного права в России является его срочный характер.
The exclusive right is the core of the intellectual property rights. It is the property right which ensures its economic viability and its marketability. What's interesting, the exclusive right in Russia is temporary in nature.
Срочность исключительного права обусловлена необходимостью соблюдения баланса публичного и частного интереса. Частный интерес правообладателя состоит в сохранении своей монополии на использование результата творческой деятельности максимально долго, а публичный интерес состоит в том, чтобы обеспечить доступность культурных, научных достижений, использование их в интересах общества в целом.
The temporary nature of exclusive rights is explained by the necessity to ensure a balance between the public and the private interest. The private interest of the copyright holder is in keeping their monopoly to the use of the result of creative activity for a maximum period of time. And the public interest lies in the fact that we need to ensure accessibility of cultural and scientific achievements and their use for the sake of the society on the whole.
Сроки действия исключительных прав различны, установлены законом в отношении различных объектов. При этом сроки в отношении результатов творческой деятельности достаточно длительные. Так, на произведение науки, литературы и искусства в течение жизни автора, а также 70 лет после его смерти, на фонограмму исполнения 50 лет.
The terms of validity of exclusive rights are different, they vary, and they are established by the law with respect to various objects. At the same time, you can see that the such terms of validity are quite lengthy for the results of creative activity. So for the works of science, literature, and art, they will be valid throughout the life of the author and 70 years after their death.
На промышленную собственность сроки действия исключительных прав короче, что объясняется нецелесообразностью в условиях бурного развития научно-технического прогресса длительное время защищать монополию на использование технических решений.
As far as intellectual property rights in the industrial sphere are concerned, the terms of validity of exclusive rights are much shorter, which is explained by the fact that it is not viable to protect the monopoly for the use of technical solutions in the context of rapid development of science and technology.
Срок исключительного права на изобретение составляет 20 лет, на полезную модель 10 лет, на промышленный образец 5 лет. Срок исключительного права на средства индивидуализации не ограничен, либо может неограниченно раз продлеваться.
So as you can see, the term of exclusive right for an invention is 20 years, for a utility model 10 years, and for industrial design or prototype 5 years. The term of the exclusive right to the means of individualization is either not limited or it can be extended repeatedly.
Государственная поддержка в области охраны объектов интеллектуальной собственности осуществляется посредством специализированных органов государственной власти. В их число входит Федеральная служба по интеллектуальной собственности.
So what is the state support in the sphere of protection of intellectual property rights? There is a special agency, there is a special government agency which ensures this work, and it includes the Federal Service for Intellectual Property, or Rospatent.
Данный орган государственной власти является Федеральной службой России, осуществляющей функции по контролю и надзору правовой охраны, использования объектов интеллектуальной собственности, патентов и товарных знаков, результатов интеллектуальной деятельности, вовлекаемых в экономический и гражданско-правовой оборот, соблюдение интересов Российской Федерации, российских физических и юридических лиц при распределении прав на результаты интеллектуальной деятельности, в том числе создаваемые в рамках международного научно-технического обмена, сотрудничества.
This federal agency is a federal service of Russia, which has the functions of controlling and supervision in the sphere of legal protection and use of the intellectual property objects, patents and trademarks and results of intellectual activity, which are involved in the economic and civil and legal circulation. They also ensure compliance with the interests of the Russian Federation, of Russian individuals and legal entities when the rights for intellectual property are distributed, including those which are created within international scientific and technical cooperation.
Органом судебной власти по защите интеллектуальных прав в случаях нарушений является суд по интеллектуальным правам. Создание специализированного суда, который рассматривал бы соответствующие споры профессионально, качественно, не только с правовой точки зрения, но и с учетом специфики того или иного интеллектуального права, подлежащего защите, необходимо для повышения как инвестиционной привлекательности российской экономики, так и эффективности системы защиты интеллектуальных прав с учетом международных стандартов.
The judiciary organ which ensures the protection of intellectual property rights in case of their infringement is the Intellectual Property Court. The necessity for creation such a specialized court which would review the disputes professionally with high quality, not only from the legal standpoint, but from the standpoint of specific or this or that branch of intellectual property rights, which is to be protected, is required to increase the investment attractiveness of Russian economy. And it is also explained by the standpoint of efficiency of the system of protecting intellectual property rights with respect to international standards.
Рассмотрение таких споров, как правило, требует наличия специальных знаний, восполнить отсутствие которых у неспециализированного суда не может и произведение экспертизы, так как сама по себе экспертиза по таким делам нуждается в очень серьезной оценке.
The review of such disputes and conflicts requires special knowledge as a rule. And a non-specialized court might very frequently not have such specialized knowledge. They might involve expert assessment, but that might not be sufficient as well, because an expert evaluation or assessment in such cases also requires very serious supervision.
Таким образом, в Российской Федерации интеллектуальное право составляет широкую область изучения, которая охватывается не только правом, но и многими смежными науками, что делает его особенным в системе права России в целом.
To conclude, I would like to say that the intellectual property rights in the Russian Federation are a very interesting subject for study. They cover not only the various branches of the law and many neighboring sciences, which makes this area of the legal studies very special in the Russian system of law on the whole.
На этом все. Благодарю за внимание. Готова ответить на вопросы.
Dear colleagues, I would like to thank you for your kind attention, and I'm ready to answer your questions, if any.
Thank you so much, Mrs. Slavkova Julia and Professor Kalanin. Am I right?
Right.
Yeah. Right, okay. I'm afraid that I incorrectly mentioned your name because of my pronunciation. Russian is quite difficult for me to pronounce Russian words. But thank you so much for the explanations. Bapak Ibu mau nanya tadi Profesor Hollis di chat box bilang bahwa more or less sama ya sistem apa namanya intellectual property right di Rusia dan Indonesia hampir mirip-mirip ya Bapak Ibu. Termasuk mungkin untuk ini ya Profesor apa validitas masa berlakunya yang tadi disampaikan di Rusia hampir sama nih Prof. Saya tanyanya, saya yang tanya nih jadinya ke Profesor Hollis sama nih Prof.
Ya, hampir sama.
Okay.
Industrial design.
Industrial design. Oh, not same. Oh, okay. Well, Professor Kalanin and Mrs. Julia Starkova, that Professor Hollis told us that more or less the intellectual property rights in between Indonesia and Russia more or less are similar, but not the same with the industrial design. Tidak sama di industrial design di Prof. Ya, Bapak Ibu tadi sudah dijelaskan oleh Prof. Hollis secara umum general hampir mirip. Nanti pertanyaannya di akhir nih, the questions will be in the last session. Gitu ya. Prof. Kalanin, you going to translate my...
Yes, sure.
Yeah, okay,
в первую очередь мы хотели бы поблагодарить вас за вашу презентацию. Она вызвала у нас обсуждение. Наша коллега доктор Холис в чате написала, что сроки защиты прав интеллектуальной собственности в России и в Индонезии во многом совпадают. Однако этого нельзя сказать о сроках защиты на индустриальные изобретения и полезные модели. Вот здесь у нас есть разница. Мы думаем, что вопросы и ответы мы перенесем на последнюю часть нашей сегодняшней конференции. Спасибо большое.
Да, спасибо.
Yeah, thank you for your comments so much.
Thank you so much for a very nice presentations. We learned a lot from Russia for the intellectual property right. Ladies and gentlemen, it is an honor for me to invite our keynote speaker, the Honorable Professor Hollis. Please do. Monggo Ibu, Profesor, silakan.
Thank you, Mbak juga. Assalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh.
I would like to say thank you for joining to my presentation and online public lecture and campus tour intellectual property right by Pancasakti University. It is great to see you all. It is an honor to meet the speaker, Mr. Joseph Bakil from Hassan Universitas Morocco. Assalamualaikum, Ms. Joseph Bakil. So, Ms. Starkova Julia from Pedagogical Moscow City University from Russia. Nice to meet you, Mr. Starkova Julia. And I say to thank for Pak Sanusi, Head of Master of Law, and Ibu Hartinah, Postgraduate Program. Good afternoon, ladies and gentlemen. I'm glad to see you all. This afternoon, I would like to presentation about Indonesian regulation of intellectual property law in Indonesia, focusing on international policy and intellectual property rights system. May help me to share my PPT, please.
Yes, sure, Ibu. Ibu, do you have you're going to be the host? Ibu mau jadi hostnya langsung?
No. I want to help for my and UPS.
To help. Okay, ada Pak. PPT-nya ada. But we don't have the materials from you, Ibu. Ya, for the second mungkin Pak Rizky sudah. Okay, Ibu, we will help you. Don't worry. It is a miscommunications. Okay, our operator is preparing. Don't worry, Ibu. Ini Profesor Khalisa ini luar biasa ya. Saya baca panjang banget, Prof, ininya, CV-nya. Jadi saya pendekin aja yang terbaru.
Because I wanna be a lecturer to 35 years.
Wow, 35 years
lecturing.
Lecture. Yeah, very long time. Okay.
Long time.
Yeah, long time. Yeah, we need to learn a lot from professor because of her experience.
Okay, this
Just
I
hold
would like to
second.
start my presentation.
Ya, sebentar Prof. Ini lagi dipersiapkan karena operatornya baru membuka WhatsApp yang dikirim Pak Rizky untuk ke ininya, PPT-nya.
Mungkin saya bisa langsung membaca ini my PPT.
Oke. Sambil baca ya Prof, nanti kita sesuaikan. Oke. Ya, sambil operatornya ini.
Oke, the title my presentation, Intellectual Property Right Regulation in Indonesia, focusing policy IPR system in Indonesia. The first, I explain the concept of intellectual property. Intellectual property source from creation of mind, form, fixation in material form, requirement protection in original and novelty, especially a patent novelty around the world, requirement protection, literary art, science work, and technology, and invention technology, and industrial property. Contraction of the creation of mind in the property individual right, and orientation protection, economic interest, and category of the creation of man, intangible movable good, law protection of the creation of man, exclusive right, for example, copyright, patent right, trademark right, design industry right, plant varieties right, and neighboring right. Yeah. Consequence of the exclusive right as a monopoly right. When the discuss of intellectual property system, we look the history of intellectual property development. Intellectual property development grew and developed from Europe state and United States state. So the development in international intellectual property rights system in Paris Convention 1883, managed by Paris Union, and Berne Convention in 1886, managed by UNIBEN. After that, in year 1961, with agree Rome Convention and Washington Treaty, managed by World Intellectual Property Organization. So the development in the year 1986, in the Uruguayan negotiate the issue of intellectual property related and trade. Finally, of the Uruguayan result trade agreement. Trade agreement managed by WTO, World Trade Organization. We discussed the frame norm of intellectual property and the norm of intellectual property system in perspective by WIPO frame and WTO frame. We look in the WIPO frame, the norm of the intellectual property system is soft law because the Paris Convention and Berne Convention and Paris Convention, the provision of reservation requirement is very lenient. and the Paris Convention and Penn Convention, noting the supervisory body for the implementation agreement. The dispute resolution mechanism is voluntary and Paris Convention and Penn Convention. Non-imperative norm, just recognition of intellectual property protection. The determination, the other character, the determination of protection standard depend on the socio-economic and cultural condition of the state party. The other hand, the norm and intellectual property system in WTO frame, determination of norm and standard of protection of intellectual property right establish full compliance. A trade agreement make obligation for the state parties ratified for convention with nothing reservation. It's like a Paris Convention, Penn Convention, Washington Treaty, and the provision of the trade agreement state law enforcement mechanism through civil, penal, and cross-border measures. The provision of the implementation of trade agreements supported by supervisory institution as Council of the TRIPS. The provision of the dispute settlement is the compulsory by dispute settlement body, and then the provision of the punishment of the trade agreement cross retaliation mechanism. The norm of the intellectual property system by in WTO frame is at hard law. And then after intellectual property system managed by WTO, and then IPR system is the harmonic system in the world, because the member of WTO is the 160 member. Almost the countries in the world is the member of the WTO. So every members of WTO make obligation create to create regulation of intellectual property refer to trade agreement, so that this is global harmonization of the intellectual property system in the world. How to Indonesia? Indonesia ratified trade agreement with Act number 7 in 1904 years, and then and consequence of the member consequence of the WTO member, Indonesia Indonesia ratified Penn Convention, Rome Convention, Washington Treaty, Patent Open Treaty, Trademark Treaty, and then renew ratified Paris Convention. And then implementation of trade agreement, Indonesia create the many regulated from intellectual property. For example, Act number it is new regulation. Act number 29 2000 year about plant varieties, Act number 20 year 2000 about trade secret or undisclosed information, Act N 31 2000 years about industrial design, then Act number 82 2000 year about integrated circuit, and this is renew regulation of intellectual property, Act number 19 2001 about trademark, about trademark, and this finally Act number 19, 20, and 2 about copyright. So we look the policy of the regulation of intellectual property. We look and pre-independent. We have reglement industrial addendum. Hindia Belanda. This is pre-independent. Sorry, Hindia Belanda have a reglement industrial addendum 1912. Outer Sweat 1912, Octroi West 1910, and Hindia Belanda Fundamental is a state parties of Paris Convention, London version 1934, and state parties of the convention, Rome version 1931. The intellectual property system in pre-independent, this is concordant principle. This is applied to Europe citizen, non-Europe citizen by submission, and customary law for indigenous people. The enforcement of intellectual property system is weak. So development and intellectual property system post-independent, we look pasal 2 aturan peralihan Konstitusi Law 1945. We have reglement industrial addendum tablet 1912 and outer sweat 1912 to be continued. Declaration continue application to Paris Convention. Indonesia to be continued state parties and Paris Convention to continue India Belanda governmental withdrawal from Bern Convention. Indonesia create a Trademark Act number it is clearly 90 in 1962, and so Indonesia ratified Paris Convention Stockholm version by Kepres number 24 1979 years with reservation in Article 1 until 12. Indonesia create Copyright Act in 1982. The policy of the intellectual property system in Indonesia post-independent is national interest protection, because the access of to science, to technology needed by Indonesia community. Limitation and IP foreigner. The regulation of intellectual property system in post-independent balancing for exclusive right and public interest. The ownership of the copyright is a social function. Exclusive right and in social function. This is balancing exclusive right and public interest. So selective to parties of intellectual property convention. Later, intellectual property protection of Indonesia in globalization or after Indonesia ratified trade agreement. Indonesia create or design strong regulation of intellectual property right system through act of trade secret, act of industrial design, act of integrated circuit, act of on plain varieties. This is a new regulation of intellectual property right refer trade agreements. Previously, the regulation is nothing. The act number 18 and 2016. This is amendment from Patent Act year 1989, Patent Act in year 1997, and amendment from Act number Patent Act number 14 year 2001. So the other regulation refer to trade agreement in trademark regulation, Act number 20 and year 20 and 16 on trademark and geographical indication. This is amendment from Act Trademark Act year 1992, Trademark Act Amendment Trademark Act in year 1997, and Amendment Trademark Act from year 2001. And Copyright Act number 28 year 2014. This is amendment from Copyright Act year 1987, Copyright Act in 1997, and Copyright Act at 2002. The regulation of intellectual property system and after ratified trade agreement, harmonize intellectual property system of the IP international system, especially trade agreement and Paris Convention, Berne Convention, Berne Convention, and Rome Convention and Washington Treaty. The policy, the regulation of IPR system, goal the creativity and innovation development, investment bargaining, full compliance to trade agreement, implemented of national treatment, and most favorite national principle. This is more concern for global trend. So we look how to intellectual property system in Indonesia cosmology. Excuse me, Mbak Yoga, I would like to this my my laptop is lowbat.
Okay.
Saya akan ini sebentar saya akan
nanti Prof siap Prof. Bapak Ibu mohon bersabar deh. Bapak Ibu kalau ini pertanyaannya ditulis dulu jadi nanti kita bisa cepat ini nanti saya tinggal menyampaikan ke Profesor atau Miss Starkova Yulia here. Prof nanti di akhir ada konklusi dalam bahasa Indonesia nih Prof.
Oke.
Thank you.
Sorry. Oke. Gimana, terdengarkah masih?
Ya, sudah. Halo, Prof. Sudah, Prof. Terdengar, Prof.
Hello. So, how intellectual property system in Indonesia cosmology? The source of IPR concept creation of the same. This is creation of mind, and the form of IPR in fixation or in material form, and then IPR system and Indonesia cosmology, non-material and material form. This the form of requirement protection, original and novelty, and Indonesia cosmology, authentication rooted in cultural tradition, then result of the IPR, literary, artistic, and scientific work and technological invention. This is the same in Indonesia cosmology. The orientation of the intellectual property protection, market oriented, this economic oriented, but the intellectual property system in Indonesia cosmology, survival and sustainable community. This contraction of the IPR concept, property right or individual right, and Indonesia cosmology, communal right, public domain, social function, individual right and social function. And then content of the IPR concept, economic and moral value, and then Indonesia cosmology, social value and sustainable development. Consequence of the intellectual property system, monopoly right, and then Indonesia cosmology, tradition sharing. And IPR concept, this is natural resource exploitation, but the Indonesia cosmology respecting preservation, safeguarding common heritage of mankind. The legal system of intellectual property system in Indonesia, this is reaction of go patent, non-based on national interest, and incorporation of global system of intellectual property, including the value to carry out for national system. This is transferability, transplantation legal system from offsite, imposed from offset, not developed but within contact, not rooted peculiar of social life, not to be done to earth. This empirical, the IPR system occupation still low. We look at the patent occupation. dominate foreigner patent right, yeah, dominate patent right. And then we look the occupation of trademark. There are just 1% of the 67 million businessmen. IPR disputes are dominated by foreign intellectual property owner, especially many dispute, many cases of the intellectual property right in Indonesia dispute on well-known trademark dispute. What the intellectual property system impact on increasing innovation? This is the question. Yeah, is it the question? We look the Profession and Patent Act number 18 year 1916 in 10 article. The profession regulate the obligation of patent owner, requirement and local production and patent. This profession make the claim of the corporate pharmaceutical from US and from Europe. And the corporate the government American government atau trade United States trade representative trade international trade from Indonesia the trade of international trade of Indonesia with through the GSP and export quota. How to influence on the intellectual property system influence on the development of innovation? This is the question. We look the innovation index, Indonesian Innovation Index.
Baik, Bapak Ibu, sambil menunggu Prof. Hollis. So ya, Bapak Ibu sudah menulis ini ya, sudah menulis. Oh, belum questionnya, lihat baru gepo. Oke, nunggu Profesor ya. Kita nunggu the keynote speaker dulu. Barangkali ada yang mau tanya dengan Russia, silakan. Based on the topic of the internet in Russia, what are the challenge? Okay, dear Miss Zulia Starkova and Prof. Konstantin Kalinin, are you still there?
Yeah.
Yeah, you see here in the chat box, there is a questions for you based on the topic about intellectual property right in Russia. What are the challenges for facing in dealing with intellectual property infringement in Russia? Is there a proper solutions to solve it?
Уважаемый господин Старкова, у нас есть вопрос в чате, который звучит так. После вашей презентации у меня возник вопрос. С какими проблемами в области нарушения авторских прав сталкивается Российская Федерация и существуют ли какие-то рабочие решения этой проблемы?
I think you have to unmute first. Yeah, I cannot hear
Нужно
your
включить
voice.
звук, потому что я вас не слышу.
Sorry.
Да, спасибо. Да, проблем достаточно много с защитой интеллектуальных прав, но самая всеобъемлющая проблема, предполагаю, с которой сталкивается большинство стран мира, это несанкционированное распространение интеллектуальной собственности в сети интернет.
Yes, I would like to thank you for your question, first of all. And to answer it, yes, there are quite a number of problems that our country is facing in the sphere of infringement of intellectual property rights, as is the case with many other countries. But I believe that the biggest of them is the unauthorized distribution of copyrighted work over the internet. Over internet.
So what is the big problem? Could you repeat, Professor Khalinin? The solution.
It is the unauthorized distribution of copyrighted works over internet.
Okay, jadi unauthorized distributions over the copyright works on the internet.
Yes, and I put it in the chat box as well.
Okay, thank you so much. Bapak Ibu, ini di chat box ada tulisannya ya. Jadi ada distribusi yang tidak unauthorized di copyright, jadi distribusi tapi tidak disebutkan ininya ya, sourcesnya copyright works di internet itu susah sekali. Jadi itu big problems di rahasia. Saya rasa di Indonesia juga sama mungkin ya. Bapak Ibu kan suka misalnya ambil musik orang atau apa di internet diupload gitu ya. Biasanya gitu, itu agak sulit untuk mengatasinya. I think this is it's very challenging to overcome this problem because of the internet is so huge, so big. Is there any cases in Russia about? Can you mention one case about this in Russia and what is the solution?
Мы думаем, что эта проблема действительно касается не только России, но и многих других стран, хотя бы потому, что интернет — это настолько глобальная среда, что уследить там за всем очень сложно. Не могли бы вы привести пример какого-то одного дела, связанного с нарушением прав интеллектуальной собственности в интернете, и как оно было решено, чем оно завершилось?
Интересно. Да. Сейчас что-нибудь сообразим. Конкретного дела, наверное, так оперативно привести не смогу, но не так давно Роспатент у нас опубликовал сведения об убытках, которые несут авторы в связи с распространением только, несанкционированным распространением только книжной продукции. Оно насчитывает ежегодно около 2 миллиардов рублей.
It would be very difficult to tell you a single specific case, but quite recently, the Russian Patent Agency, the Rospatent, published a report in which it stated that unauthorized distribution of books, only books, was equal to 2 billion rubles.
Wow, 2 billion rubles. Okay, so that's the loss.
That's the loss.
Okay, that's the loss. Jadi Bapak Ibu ada satu kasus dia copyright books ya di Rusia yang baru-baru saja ini, itu apa namanya, kerugiannya 2 billion rubles, right? 2 billion.
Yes, exactly.
Ya, 2 billion. 2 miliar rubles ya. 2 miliar rubles kerugiannya karena copyright yang unauthorized, tapi buku ya Bapak Ibu, bukan yang lainnya. Ini saya tadi tanya satu kasus di Rusia yang bisa disebutkan untuk infringement, property infringement, intellectual property infringement atau violations. Well, thank you so much, Professor Khalinin and Mrs. Starkova Julia. That's quite difficult for me to pronounce the Russian's name. Anyway, thank you. We are back to Professor Hollis. Professor Hollis, are you still here? Thank you so much for the answers.
Большое спасибо за ваши ответы. Спасибо. Thank you.
Spasiba, right? Spasiba.
Yes.
Right.
Yeah, Professor Elsin told me yesterday. Spasiba, okay. Professor Hollis, are you there? Ibu, Profesor.
Suaranya belum masuk.
Suaranya siapa? Dari sananya. Iya. Gimana nih Pak? Ini jamnya ini mundur berarti. Bu Hollis, halo Profesor Hollis, Roisa. Kayaknya tidak di mute, connecting to audio. Okay. Ya, lagi connecting to the audio. Oke, Bapak Ibu, ini contohnya ya Bapak Ibu, ada spesifik di chat box. Bapak Ibu lihat di kerugiannya. Oke. Oh, million. Di sini juta, 22.7,5 juta US dollars. US dollars, kalau di sana 2 billion ya. Oke. Oh, oke. Ya, Profesor Hollis, are you there? Ya, baik. Bapak Ibu ada pertanyaan lagi sambil menunggu Prof Hollis? Tapi nanti berarti nggak usah nanya lagi waktunya, soalnya kita manajemen waktu. We have to think about the time management. Bapak Ibu ada yang mau nanya lagi ke Miss Julia Starkova? Oh, Starkova, Julia. Oh, enough. Okay. Jadi satu aja, only one question. That's the answer. Kita menunggu Prof Hollis ya. Pak Rizky bisa ditelepon beliaunya. Oh, sudah masuk? Coba cek. Halo, Profesor. Kayaknya belum masuk deh. Professor, hello. Sorry for the technical problems. Internet connection, I think. Professor. Ya, Bapak Ibu sekalian tadi saya pamitkan ya. Mr. Yosef Akil ask your permissions. He must he has different urgent agenda this morning. He has to go to the office. That is why he was leaving earlier. And he sends his best regards for everyone here. Dapat salam dari Mr. Yosef Akil untuk Bapak Ibu semua. Dan mohon maaf yang sebesar-besarnya karena beliau ada urgent agenda yang harus tidak bisa ditinggalkan. Beliau kerja di Kementerian Dalam Negeri di Morocco ya, Bapak Ibu. Selain di Hasan First University. Professor, are you there? Belum, Pak. Gimana Pak Rizky ini? Wait a moment. Halo, Prof. Profesor. Kalau mic dari sananya biasanya kita nggak bisa bantuin. Iya, karena itu technical problem di sana. Kecuali profesornya di sini. Halo, Professor, are you there?
Bu Yoga masih di mute.
Thank you. Hello, Miss Julia Starkova Julia, sorry, and Professor Kalinin. If you have the urgent agenda, I mean that if you are busy today, because Professor Hollis, he's connecting the audio now. Oh, great. Professor, okay, Professor. Halo Ibu Profesor, sudah bisa? Prof? Langsung ke tanya jawab nih Prof. Prof di mute Prof. Prof masih mute.
Audionya memang bermasalah.
Oh, audionya. Profesor, gimana ini Prof? Ini
boleh kalau kan misalkan teknologinya pakai HP nggak apa-apa. Dia kalau mau login dia
Pak, aku kok sorry nggak jadi. Kita nunggu profesor nih berarti.
Iya, suruh ini pakai HP aja.
Bapak Ibu mohon bersabar ya. We do really sorry. We are waiting for professor and one questions and then we finish. Prof. Kalinin, could you tell Miss Starkova Julia for this?
Да. Старкова, у нас просто последний спикер никак не может подключиться, чтобы ответить на один вопрос. Но, в принципе, ждем вот этого момента, и тогда мы сможем завершить нашу конференцию.
Да, мы будем ждать решения проблемы.
Yes, we hope that this problem will be resolved.
Yeah, I think he's here already. He's here. Halo, Prof. Professor. Do you have the video profile that you're going to show us? Prof. Kalinin, do you have the video profile that you're going to show us?
No, I'm not a speaker. I'm just interpreting. So.
Okay, thank you. I mean the video profile of law faculty of Samara University. Do you have it? Because last time I asked Professor Elsin to provide the campus tour for law faculty. I will forward this question to him, but he has not instructed me. Okay, that's okay. It's okay, no problem. It's okay. We are honored you are here. We are very happy you are here. Professor Hollis, thank you so much. Ya, Profesor. Bapak Ibu kalau mau tanya langsung aja di chat, nanti dijawab sama Profesor Khaliso ya. Ladies and gentlemen, we have come to the question and answer sessions. You may ask one question only for Profesor Khaliso. Silakan Bapak Ibu, satu pertanyaan untuk Profesor Khaliso. Di chat. Tidak ada? Atau ada Bapak Ibu? Halo? Ada yang mau tanya nggak? Oh, cukup. Professor Holisa, there is no questions from the students here. Are you sure? Yakin? Bapak Ibu, ini ada Profesor Holisa loh dari Undip. Beliau 30 tahun mengajar hukum di Fakultas Hukum Undip. Nggak ada yang tanya, Bapak Ibu? Are you sure for that? Atau nanti chat Japri langsung aja ke beliau. Oh, Japri ya. Oh, Prof, katanya mereka mau Japri, Prof. Oke.
Malu Prof, soalnya Prof.
Ya katanya Japri biar tambah kenal, kalau nggak kenal nggak sayang, Prof, katanya gitu, Prof. Nanti saya Japri duluan deh. Oke.
I'm sorry, my speaker is trouble.
Yeah, thank you so much for Professor Holisa, Professor Hollis for being here. Thank you so much for Miss Julia, Ustaz Kofa Julia and Professor Kalinin to be here. We are greatly honored that all of the speakers give us very fruitful contributions to the development of law in the future. I mean, in the field of law in the future. Thank you so much for being here. Ladies and gentlemen, we have come to the end of the agenda. Let's say hamdalah together.
Alhamdulillahirabbil alamin.
Thank you so much for today. Assalamualaikum warahmatullahi wabarakatuh. Thank you, Bapak Ibu. Terima kasih. Thank you so much. Bye bye. Thank you. Thank you so much. Bye bye.
Have a nice day. Stay safe.
Yeah, have a nice day and stay safe for everyone.
I love you.
Thank you.
Thank you, thank you.
Bisa di